Hello, my name is Fiona Kellas. I'm a partner from the firm Maucher Jenkins, and I'm here today to tell you about patents. Patents are a form of intellectual property, and they're used to protect inventions. So what is a patent? Well, a patent is a state-granted monopoly right that's provided in exchange for 20 years from filing an application. It's granted in exchange for a full disclosure of the invention, and it provides an exclusive right to stop others from making, using, selling, offering to sell, and importing your invention without your permission. So what is patentable? Well, to get a patent granted, you need to meet certain requirements. So firstly, your invention needs to be new, novel, so that means that it's not already been published, it's not already in the public domain. It needs to be inventive. That means that it wouldn't be obvious to somebody who's working in the same field to arrive at your invention. It needs to be capable of industrial application. That means that it must be applicable to industry. And it's important that it doesn't fall in one of the excluded categories. So some of the patent offices have exclusions from patentability, so you can't get a patent granted for a method of treatment or some computer-related inventions. So I've made an invention. What should I do now? Well, firstly, it's very important that you don't tell anybody about it unless it's under a confidentiality agreement, otherwise known as a non-disclosure agreement. We'd recommend that you speak to a patent attorney who can give you advice as to how to proceed, and then, assuming that you want to proceed, then file a patent application. So you've decided that you'd like to go ahead and file a patent application. Where should you file first? Where geographically should you file first? Well, we would recommend filing initially at the UK Patent Office. That's because at the UK Patent Office, the official fees are lower. So it's a low-cost route to planting your flag and establishing a filing date. Then you could consider filing in other countries, depending on where your markets are, where your competitors are based, and where you will be making the invention. So I filed a UK patent application. What happens next? Well, at 3 to 6 months from filing, you'll receive a search report from the UK Patent Office. And this will give you an indication as to whether there are any previously published documents that are considered relevant to your invention. Then at 12 months from filing, you'll have the opportunity to file overseas. So your further application would then date back to the original filing date of your UK application. Then at 18 months from filing, your application will be published. And at 24 months from filing, you will need to request examination of your application. Examination in the UK must be completed within 4.5 years from filing. This process can take longer in some other patent offices. So this next slide shows you an overview of what I've just described. So you file first in the UK, and then on the right-hand side, you can see the process in the UK where there's a search and examination process, and then your application is granted within around 4.5 years from the filing date. Alternatively, you can file a further application that dates back to the original filing date, that claims priority from the original filing date, and that further application might be an international PCT application. The international application is published, and then you have the opportunity to file the international application in the national countries of interest. So for example, on the slide, you can see filing in the US and Europe and China. Those applications are examined by the national patent offices and then eventually, hopefully, then granted. So what about trade secrets? Should I consider trade secrets instead of filing a patent application? Well, there are certain circumstances where trade secrets might be used. So for example, perhaps your invention doesn't meet the patentability criteria, so it's not considered to be new and inventive. Or perhaps you don't want your invention to be published. As I mentioned with patents, your application will be published 18 months from filing. You might not want to have it published, and so you could rely on trade secrets. If you do rely on trade secrets, it's really important that you keep that information confidential. So all documents must be restricted in release, and they must be marked as confidential. The best option is to file a patent application. That gives you the security of planting your flag and establishing a filing date. However, as I said, there may be circumstances where trade secrets could be used. So just to summarise what I've described, so of key importance is that you should not disclose your invention until you filed a patent application. That's really important because if you disclose it before filing a patent application, you might have lost the opportunity to get a patent granted to protect it. You might put in place a confidentiality agreement, but the best thing to do is to file a patent application before telling others about your invention. We would typically, as I said, file first at the UK Patent Office to plant your flag and then file further applications derived from that application at the 12-month period. And we would also recommend speaking to an IP professional who'll be able to give you advice on patentability, help you draft your application and prepare it, file it at the Patent Office and take you through the next stages of the process. So just to give you a bit of information about Maucher Jenkins and who we are, we're an Anglo-German firm. We have offices in the UK as well as in Germany, and we have 2 offices in China. And these are our contact details. You're very welcome to get in touch and to ask us any questions that you might have.